is your first appearance before the subcommittee, but we look forward to working with you, both of you also. Thanks for being here today. The work of the judiciary is critical to the preservation of our nation's system of government, where each of the three branches have different responsibilities and checks on the other branches. Americans depend on an open, accessible, and well-funded federal court system to resolve criminal, civil, and bankruptcy disputes. The courts must have the trust and respect of our citizens to the function of the Founding Fathers intended. So in addition to the judiciary's probation and pretrial service, officers perform critical public safety missions by supervising more than 200,000 offenders and defendants who live and work in our communities. And as you know, the federal government continues to operate in an environment of scarce resources. However, we'll try to ensure that you have the resources that you need to accomplish your important mission. Over the past few years, you and your staff have worked closely with us to ensure that the judiciary receives increases to address only your most critical needs. And I thank you for your efforts to try to reduce costs during these challenging times. The judiciary's budget request proposes a discretionary spending increase of about $220 million. That's about 3.4% above the fiscal year 2014. And I'm very appreciative of the fact that your request is a modest increase, but remember, funding remains scarce. So I want to work with you. I want to work with the Ranking Member Serrano to identify any savings that we can find in the judiciary's cost, but we still want to provide the courts with the resources that you need to fulfill your constitutional responsibilities. So I appreciate the important work that you do. Look forward to your testimony. And now I'd like to recognize my friend, Ranking Member Serrano.
Thank you, Mr. Chairman. I would also like to welcome Judge Gibbons back for her 10th time. If it was a baseball contract, I think you'd have a pension by now. That's the best pension in the world, I hear. Back to the subcommittee, and Judge Bates, you're the rookie, but you'll quickly find out that this is a very friendly committee, especially last year as it was to this particular branch. There have been some significant challenges for the federal judiciary over the past year. Sequestration had an extremely negative impact on the ability of the federal judiciary to function and for the various parts of the third branch to conduct its important constitutional duties. And although the federal judiciary was able to operate during the last fall's government shutdown, there were delays in trials and other pressing matters. Thankfully, there has been some good news of late, in part because of your testimony here last year. I think many members of Congress were persuaded of the vital need for additional funding for the judiciary, and the final fiscal year 2014 bill substantially reflected that need. We were able to increase funding for the federal judiciary by $316 million above the sequester level, which helped restore most, but not all, of the funding cuts that affected the judiciary through sequestration. I hope we will get a chance to discuss the impact of sequestration on the federal court system and whether this additional funding has been able to restore services. Your fiscal year 2015 budget request indicates that there is more work to be done in order to restore the ability of the judiciary to conduct fair and speedy trials, to help recently incarcerated individuals transition back into society, and to provide numerous pretrial services, among other things. One area that is of particular concern to me is our federal defenders. Cuts both prior to and during sequestration resulted in both layoffs and significant furloughs during sequestration. Our federal defenders play a vital role in upholding the Sixth Amendment's right to counsel, and I hope we get a chance to discuss how their work has been impacted by the sequester. As I said last year, the role of the federal judiciary extends beyond the courtroom and into all of our communities. This means that your funding is not just relevant for litigants, but for this nation as a whole. We all perhaps take for granted in this country that every person can have a fair and speedy trial, but it is up to Congress to ensure that you have the funding to make these constitutional promises a reality. Once again, welcome, and I look forward to your testimony. Thank you, Mr. Chairman.
Thank you. I think we'll have time to hear opening statement from Judge Gibbons. And Judge Gibbons, let me say that your written statement will be made part of the record, so take in the neighborhood of 5 minutes to summarize that. So the floor is yours.
Judge Bates and I appreciate the opportunity you've given us I'm going to move as fast as somebody with a drawl can. When I appeared before this committee last year, sequestration cuts were just going into effect, and I predicted dire consequences for the judiciary. Our fears were realized. Sequestration resulted in delays in case processing, reduced services at courthouses nationwide, caused large staffing losses in clerks of courts offices and probation and pretrial services offices. We reduced funding for court security equipment, and court security officers worked fewer hours, thus creating security vulnerabilities. Perhaps the most significant impact was in our Defender Services Program, which provides court-appointed counsel for indigent defendants. Federal defender organizations lost 400 staff during 2013, an 11% loss, and widespread furloughs were implemented. In addition, a $15 per hour temporary rate cut to panel attorney hourly rates was implemented on September 1, 2013, on an emergency basis, an unprecedented action. This subcommittee, the overall Appropriations Committee, responded with help through the funding you provided us in FY 2014 in the Omnibus Appropriations Bill. We're very appreciative of the 5.1% increase in discretionary appropriations, which essentially restored us to a pre-sequestration funding level. This funding stabilizes our financial position and allows us to reverse most of the emergency measures put in place due to sequestration. We will be able to backfill some of the more than 3,200 staff lost in recent years in clerks and offices in probation and pretrial services offices, and will provide sufficient funding to meet operational expenses. We're particularly appreciative of the funding you provided for the Defender Services Program. We have been able to restore, effective March 1, the $15 cut to panel attorney hourly rates, and to begin backfilling the 400 staff lost in defender organizations. We anticipate this will take at least 2 years to accomplish, but we are committed to restoring the program to its former strength. And with your help, we can do that. We continue our decade-long effort to reduce growth in the judiciary's budget in order to position ourselves for future fiscal realities. We have some real cost containment successes, but we realize there's more work to do. My written testimony discusses in detail our efforts to reduce the judiciary's space footprint. We take your concerns about that seriously. We're pursuing a multifaceted approach to space reduction, including reducing the judiciary space 3% by the end of FY 2018. We'll work hard to meet this goal. There are several Chief District Judges in town for their annual meeting who've joined us today. They are on the front lines in the courts, implementing cost-saving practices, some of which are national programs and some of which are locally grown. I want to recognize each of them briefly. Judge Gloria Navarro of Nevada. Her court has developed the e-voucher system that is being enhanced to implement it as a national system. This system will automate the current paper voucher process for paying CJA panel attorneys. Judge Ricardo Hinojosa of the Southern District of Texas. His court is a national leader in judicial administration, and over 25 years ago was the first in the country to consolidate bankruptcy and district clerks' offices. We have with us Judge Catherine Vattel of the District of Kansas and Judge Rainer Collins of Arizona, both leaders in the area of shared administrative services, which will enable us to streamline operations by having courts within a judicial district share HR, IT, and other resources. 30% of courts nationally have adopted such arrangements. Judge Jerry Simandl of New Jersey has been at the forefront of efforts to reduce space. His district reduced the space needs of probation offices, in one case moving probation from leased space into a courthouse, and in another releasing excess probation space to GSA. We also have some bankruptcy judges who are here in town for their conference. Judge Bill Glenn of the Middle District of Florida, whom I know you know well, Chairman Crenshaw, and Judge Ron Pearson of the Southern District of West Virginia. The bankruptcy courts were pioneers in many of the automation efforts that are now used by all courts. For FY 2015, we seek $6.7 billion in discretionary appropriations, a 3.4% increase. This is the minimum amount required to meet our constitutional and statutory responsibilities. This is a current services budget that would simply maintain 2014 operations and allow continued recovery post-sequestration. There are $216 million for adjustments to base for standard pay and non-pay changes, and a total of $3 million for 2 small program increases. We're not requesting any new staff beyond that funded for 14. In closing, both of you have been tremendous supporters of the judiciary, and I hope we will earn that support in the future. As you make decisions for the agencies under your committee's jurisdiction, we ask that you take into account our unique constitutional role in our system of government. In return, we commit to you that we will continue to be good fiscal stewards, cutting costs where possible, spending the dollars wisely, and making smart investments to achieve long-term savings. I ask my statement be placed in the record along with those of the other court entities whom we represent. Thank you.
Thank you, Judge Gibbons. Judge Bates, I think we'll save your remarks when we come back. There's a little less than 2 minutes left. There are 3 votes, actually, so it'll take about 15 minutes. But we'll come back, and some of the other members that are in other subcommittee meetings, we'll see how all that goes. But if you don't mind, I apologize, but we don't plan the floor schedule around here. So we'll be back as quick as we can. So this will be in recess. Thanks.
That's fine. We appreciate it.
The meeting will come back to order. There'll probably be some members straggling in or out, but let's continue. And Judge Bates, the floor is yours.
Chairman Crenshaw, Representative Serrano, I'm pleased to appear before you to present the fiscal year 2015 budget request for the Administrative Office of the U.S. Courts and to support the overall request for the judicial branch. And I join Judge Gibbons in thanking you and the other members of the committee for the support that you've provided to the judiciary during these difficult economic times, which has enabled us now to address critical funding shortfalls in the Defender Services Program and in the courts nationwide. Last summer, the Chief Justice appointed me as Director of the Administrative Office. I've been a federal judge since 2001, serving on the United States District Court for the District of Columbia, and as the presiding judge of the Foreign Intelligence Surveillance Court until early last year. I continue to carry a reduced caseload on the D.C. District Court, but my primary focus now is the management of the Administrative Office. I'd like to thank the committee as well for its past support of the judiciary's Capital Security Program, funded within the General Services Administration appropriation in both fiscal years 2012 and 13. The Capital Security Program was designed to address the most serious security deficiencies in existing courthouses where renovation is a viable alternative to new construction. Unfortunately, the program was not funded in fiscal year 2014. To give you some background, this program was an outgrowth of the judiciary's long-range facilities planning process and one of our first cost containment initiatives begun back in 2008. Under the new process, greater emphasis is placed on space rather than security when determining the need for a new courthouse. As a result, the Capital Security Program provides a way for districts to address immediate security deficiencies in a timely and significantly less costly manner than constructing a new courthouse. We were pleased to see that the President's budget includes $20 million for this program in fiscal year 2015, and we urge the committee to support the GSA request in its appropriations bill. Funding for the judiciary's Capital Security Program should not, however, be a substitute for new courthouse construction. While that program may address a court's immediate security deficiencies, it does nothing to address those courts that combine both security deficiencies and an extreme lack of space. In these circumstances, the only resolution is to build a new courthouse or an annex to meet the operational needs of the court. The judiciary does not itself request funding for the construction of new courthouses. Because GSA builds our facilities, these monies come under the jurisdiction of the executive branch and are included in GSA's budget. Unfortunately, in 4 of the last 5 years, the President's budget has included no funding for courthouse construction. This year, the President's budget request for GSA includes $745 million for new executive branch construction projects, but no funding for any new courthouse projects. This is particularly troublesome given the efforts that the judiciary has taken to improve its courthouse planning with a focus on cost containment. Attached to my written testimony is the judiciary's interim 5-year plan for courthouse projects for the next 5 fiscal years that I asked be included in the official hearing record. That plan lists the same construction priorities as the 2014 plan, except that the funding for Mobile, Alabama, through the Consolidated Appropriations Act has eliminated that from the list. Nashville, Tennessee is now the judiciary's top courthouse priority in fiscal year 2015. We're very pleased that the President's budget includes funding for the Capital Security Program, but it is imperative that the judiciary also be able to move its courthouse construction program forward. We respectfully ask, therefore, that you include funding for the new Nashville courthouse in the GSA's Federal Buildings Fund in your fiscal year 2015 appropriations bill. The Administrative Office was created by Congress back in 1939 to assist the federal courts in fulfilling their mission to provide equal justice under law. The AO does not operate as a headquarters for the court, but rather provides administrative support to the Judicial Conference, its 25 committees, the over 2,300 judicial officers, and more than 28,000 court employees. Service to the courts has been and remains our basic mission. In January 2011, a task force began looking at ways that the AO could ensure that it would be able to meet its core responsibilities during this era of fiscal constraint and reduced resources. Last summer, a significant restructuring and consolidation was announced to be implemented by the end of the fiscal year, and our new organizational structure is now in place and functioning smoothly. The goals of the AO restructuring were to reduce operating costs and duplication of effort, simplify the agency's administrative structure, create opportunities for greater efficiencies, and enhance service to the courts, the Judicial Conference, and the public. That new structure is leaner and more integrated. The fiscal year 2015 appropriations request for the AO is $84,399,000. That is a $3.2 million increase, which supports a current services budget. There are no additional staff or program increases included in that request. Over the last few years, the AO has downsized its workforce by 8% through attrition, buyouts and early outs, imposing hiring caps and leaving positions vacant, and through cost containment efforts. More recently, the AO's reorganization provides us with the flexibility to better align our existing staff in order to carry out the AO's statutory responsibilities. I recognize that fiscal year 2015 will be another difficult year as the committee attempts to meet the funding needs of the agencies and programs under your purview. In making your funding decisions, I hope you will consider the significant role that the AO plays in supporting the courts and the mission of the judiciary. Thank you again for the opportunity to be here today, and I would be pleased to answer any questions.
Well, thank you all very much. We're going to observe our 5-minute rule for the members, and so you all, as you give your answers, kind of bear that in mind. I'll recognize folks based on seniority that were here when the meeting started, and the latecomers will be recognized in the order in which they came. Who came in first, Mr. Graves, you or Mr. Yoder? Okay. Sitting down is important. Well, let me start by thanking you all for your testimony. And I know last year we talked some about the fact that rental space is a big part of your budget, and I think this year it's like $1 billion. I want to find out if you're continuing to work on that. I think last year there was $50 million, kind of some cost containment initiatives. This year I think you've asked for $10 million to continue that. So tell us how all that's working out. How did the money from last year, how's that being spent? What do you plan to do for next year? And big picture, how are we doing on reducing our footprint?
I'm going to start with the big picture. As you know, we've been doing a lot for a long time in the space area. Presently, our focus is on 2 national policies that were approved by the Judicial Conference in September of 2013. The first is our 3% national space reduction target, which we hope to achieve by the end of FY 2018. The second is a policy we're calling No Net New. And the principles behind that are that any space increase must be offset by an equivalent space reduction in the same year. Accepted from these 2 policy initiatives are space that is congressionally approved. Circuit councils will be submitting their plans for achieving the space reduction goal by May. We're employing a number of different strategies to get to these goals. First would be our Integrated Workplace Initiative, IWI. And the principle there is that the growth of technology and the possibility of telework have made a different and cheaper workplace appropriate in some settings. These require money to modify the workplace, but over time they save money. To give you just one example, Chicago is moving its probation from leased space back to the courthouse for a 50% reduction in occupied space, but it costs $3.4 million to install phone lines, cables, move walls, partitions, create cubicles. That cost is going to be $3.4 million. That $10 million figure you alluded to is, I'm not sure that all of the IWI initiatives add up to $10 million. I think it's probably more, but that figure you refer to is a part of all the math we go through to get to the point that we have to have some money to save money in the long run. This construction in Chicago will cost $3.4 million, but overall, the savings to us will be substantial. Another strategy we're employing is releasing non-resident courthouse space. 6 of those facilities were released in 12, 4 more in 13. We've already garnered a savings of about $1 million a year, and we expect to proceed along those lines in other areas. We're looking at reducing library space, and we've provided some incentives to the courts for giving up space. Coupled with these new initiatives, we're still continuing to emphasize our long-standing efforts to validate the rent we are charged and to hold GSA accountable for the bills it sends us to make sure we're getting billed for what we in fact occupy. And we are continuing programs like the circuit rent budget that enable us to prioritize the money we receive appropriately.
That's great. Thank you very much. Mr. Serrano?
Thank you, Mr. Chairman. And again, welcome to both of you. As you know, I have been greatly concerned about the impact of sequestration in our federal defenders program, who perform an important constitutional roles in upholding the Sixth Amendment's right to counsel for indigent defendants. My understanding is that our federal defenders lost more than 400 employees last year because of sequestration. Because of these concerns, this subcommittee provided an overall funding level of $1.44 billion for defender services in 2014. With this additional funding, what steps is the judiciary taking to rebuild federal defenders' offices to pre-sequestration levels?
The funds that were provided for 2014 will enable the defender offices to replace about 350 of the 400 employees lost, so most of the losses can be replaced. We've been able, with the panel attorneys, to restore the rate that they had, the normal statutory rate, and so that too has been done, plus the panel attorneys received a small increase. The defenders have had trouble, or having trouble, backfilling all of these vacancies. It's a very uncertain time still budgetarily, but we believe that carrying forward the funds over 2 years, that they will be able to make substantial progress in restoring the defender offices to their prior strength. We are committed to that, and we are working with this. We are committed to working with this committee to do that.
Okay, and so you say you work jointly with the defenders to make sure that you can get them up to the level that they should be at?
Well, they have to take the steps to hire, obviously,
Right.
But and that's not as easy a task as it seems, and that's why the damage to the program was really very unfortunate.
Right.
Because you have to identify able attorneys, you have to bring them up to speed. It's not the same thing as hiring just somebody who's more readily available, but they'll get it done, and they're working on it, and we're encouraging them to move to hire, even though the future's not entirely clear.
Right. Any comments?
No, I think Judge Gibbons is answering.
Okay, that's fine. Let me ask you, as you know, I have always had a special interest in issues affecting Puerto Rico. Maybe it has a little something to do with the fact that I was born there. Lately, I've heard some troubling reports about the federal courthouse complex in San Juan, in the Alto Rey section. My understanding is that there have been some serious security breaches at the complex. Are you all aware of this issue, and are there plans in place to better secure the complex? Also, I know this is more of an issue for GSA, but has the judiciary discussed construction possibility of a new courthouse in San Juan?
We are aware of the security issues, and indeed they are being worked on. At this time, there is staff from the administrative office, including the head of our office dealing with facilities and security, down in San Juan, assessing the situation and working with GSA and the local court officials to address those security concerns. There also is a project ongoing, a capital security program project going on there in San Juan that is helping to address the security deficiencies that have been identified in Hato Rey. So we are working very diligently on that. There is a security study that is being done and will be completed in a few months, and I would expect that improvements can be made. With respect to a new courthouse, I think that that's something that GSA has agreed to begin a feasibility study of, and we will work with them and again with all the court officials down in San Juan to assess that situation and see if the answer is a new courthouse.
So you have both security concerns being discussed now. You're working with folks down there to see if you could come up with a better idea of securing the existing facility, and GSA is leading a study to see if there's a need for a new courthouse.
They've agreed to begin a feasibility study of the courthouse, looking at all the federal real estate holdings and determine whether a new building or annex or some new construction is necessary.
Right.
On the security side, we know what the security issues are, and those are being addressed both through the Capital Security Program project that is underway there. It's one of our lead projects. Through funding from fiscal years 2012 and 13, and through the assessment that's ongoing at this time.
Thank you. Thank you to both.
Thank you. Mr. Graves.
Thank you, Mr. Chairman. Thank you all for being here today. And Judge, I just, Judge Bates, wanted to see if you could elaborate a little bit on a part of your, and I guess it was submitted for the record, your statement as it related to the immigration proposal that was passed in the Senate. And in your comments, you indicate that it would take a tremendous amount of additional resources if the law was in fact enacted. And while the law, as it was proposed, provided some resources, it wasn't adequate. Would it be possible to elaborate on what you would foresee if that law or other forms of immigration reform were adopted? What kind of resources and really why, I guess what would be the reasoning for additional resources to help us navigate that as we think and move ahead?
I would be happy to. The impact of immigration reform legislation on the courts could be substantial, but it does depend on the specifics of any bill that eventually passes. The judiciary has no position on the substantive policy issues that are for the political branches to resolve, although we have provided some specific comments both to the Senate Judiciary Committee prior to that bill coming out of the Senate and to Chairman Goodlatte and the House Judiciary Committee. The cost to the judiciary really results from increased cases coming into the court system. That workload could be great, depending how many new cases. There could be new crimes. Some of the proposals have included new crimes being established and also enhanced penalties. And those could result in additional needs, particularly in the border courts. And those needs would include possibly additional judges, court staff, probation and pretrial services officers, and the federal public defenders who are representing these individuals, as well as the panel attorneys who are paid for through our appropriations. The Senate bill does include billions of dollars for the executive branch. It's through a trust fund that's been set up, and that will result in expanded enforcement of existing provisions and new provisions in that bill, but there are virtually no resources for the judiciary, which would be involved in that enforcement effort through cases brought into court, except for a small piece that goes to a specific area in Arizona, the Tucson sector. Even now, the Judicial Conference has included a request for additional judges in the border courts, but this immigration legislation could make that need much more acute. And we simply feel that it's important to point out that the judiciary has resource needs in all these areas that could result from whatever the specifics of the bill might be.
When you reference new cases, is it because the law creates new crimes, or Is it because there's additional resources being provided that provide for more enforcement, which therefore leads to more cases? I guess ultimately the question being, given the current law as we have it today, the laws that are governing us now, do you have adequate resources to enforce, or the resources that are there the necessary resources there to enforce the current laws, or do you see that it's inadequate at this point, and that these proposals that are out there, whether in the House or the Senate, are creating additional laws or enforcement mechanisms that create the need for additional resources?
The answer to the current situation is the judiciary absolutely does its best to handle the work that comes into the courts. The border courts are strapped. They are working very, very hard. All sectors, the judges, the staff, the probation officers, the federal defenders, but they are meeting the needs. Do they need more resources? Yes, but not as acutely as would be true if new legislation both creates additional enforcement by the Department of Justice and perhaps even adds new crimes and enhanced penalties that would lead to more cases.
Okay. Thank you. Thank you, Mr. Chairman.
Mr. Quigley.
Thank you, Mr. Chairman. Good afternoon, judges. I, too, have, since I got here last year, tried to do what I can for the Defender program. As I mentioned, I was a criminal defense attorney for 10 years, 26 in California, highest conviction rate in the county. That was funnier last year, I guess. I understand a couple things. First, on the rehiring, is it the first practice to rehire those we lost before in the cuts?
I don't know. I think that would be dependent on each particular federal defender's or community defender's decision-making processes, and that's not something that would be centrally determined in any way.
It would sort of make sense, though, since they've done the job before and had
Well, yes, but you know, uncertainty makes it difficult to rehire if those people have moved on to other opportunities.
You mean uncertainty that they're not sure we're going to do this again or not?
Well, or they might be uncertain that who's to guarantee they could be reasonably assured probably of remaining employed for a period of 2 years, but they may have learned a hard lesson and they may not want to be here there in 16.
I understand. I also hear that the executive and budget committees of the Judicial Conference have talked about a one-size-fits-all program for defenders, and that they're going to be asked to create all carry the same number of cases. I don't know if you've heard this or not. Regardless of the type of case that they handle, or
no, well, your information is, first I will say, inaccurate. There are a couple of things that you might be referring to that are ongoing, taken into account in
it's not the first time a judge has told me I'm wrong, just so you know. It used to happen on a daily basis.
Well,
and I always said, okay.
Well,
we're just hoping not to get the same today from you.
You know, there's probably, I can understand that there are a lot of fears out there, but that particular one is not one for a defender to be concerned about.
What would they
allocation?
have heard?
I don't know, but I can tell you. I think in the course of this answer, I'll tell you what you might have heard about.
Okay.
Currently, allocations to individual defender offices in individual districts are based on case weights. That is not a one-size-fits-all method, because the whole idea of that is different cases are different. For example, under a case weight system, as you might expect, a murder is an 8.6 under their numerical system. A bank robbery is 2.6. Possession of marijuana is 0.34. Illegal entry, 0.15. There is a concern, and this I imagine is what you heard, There is a concern about apparent disparities in workload among defender offices. And we have defender offices where the individual lawyers carry workloads far below a national average, and offices where they carry a caseload that's far above. And there might be reasons for those, but they're not reasons that are accounted for by case weights. One of the efforts that's ongoing, not in an effort to have every court every defender office look exactly the same, but in an effort to more assess staffing needs, is the development of work measurement formulas. The case weights, which do differentiate, will be a part of the work measurement formula. This is a staffing assessment methodology that we've used successfully in clerks' offices and probation and pretrial services offices for years. It's not perfect. When you get it, it has to be taken with a grain of salt, but it's still the best, most objective method we know for trying to assess staff needs. But in the defender world, they've not had a work measurement formula before. So there is concern, some degree of angst probably about that. But I think when you look at how they're developed more closely, that particular fear that you articulated is not one that ought to exist. A further part of that, a further thing that goes to mitigate the fear, is that there's precedent within the formulas for the use of subsets of formulas so you might have different offices treated differently, but treated the same as other offices that are similarly situated. So there are a lot of nuances here that sometimes get lost in the shuffle.
And I'll yield back. I just want you to know, Judge, obviously we don't pull this out of thin air. It's percolating from something.
I understand that, and I'm sure you've heard it, but believe me, we've heard it too.
Very good. Thank you.
Thank you. Mr. Yoder.
Thank you, Mr. Chairman. Thank you both for coming to testify today. It is certainly one of our more important tasks as we determine how we make sure that resources are available for the judicial branch. And I think many of us look at our work here as not just another federal agency, certainly, but an entire branch of government. In many cases, well, in all cases, the work you do is brought to you, not work you seek or cases that you've gone out and found. In fact, you can't do that. And so you've got the burdens that are put before you, regardless of whether you have the resources. They're there. And so we want to make sure that we have the resources properly allocated. We want to make sure that we are resolving disputes in a timely fashion and making sure the law is enforced properly in this country. A couple questions related to just how we have appropriated dollars. And I want to thank Judge Bates for, I think at least in your written testimony, discussing the temporary judgeships issue. And I think it's an important one. It needs to be acknowledged before the committee that we have a number of temporary judgeships. One of them happens to be in Kansas and then certainly in a number of other states. And we have extended those temporary judgeships every year. My hope, of course, my strong wishes will be this committee would continue that practice to ensure that those judgeships are available. I wonder what our long-term solution is for this issue. Every year it comes up. Every year we work on it to fix it, and this committee does their work. Certainly, we'd, I think, all appreciate if the authorizing committee, the Judiciary Committee, maybe permanently made these positions available. But what are your thoughts on how we move forward, and what's the future look like? And thanks for your support on those.
Let me start by thanking you and the other members of the committee for including language in the fiscal year 2014 Consolidated Appropriations Act that extended the temporary judgeships in 9 courts, including Kansas. You've identified the long-term solution, and that is for the authorizers to convert some of these temporary judgeships to permanent judgeships. And indeed, that's the hope of the Judicial Conference. That's what the Judicial Conference has requested with respect to 8 of the 9 temporary judgeships which were extended this last fiscal year. And that is what the long-term solution has to be. Those courts need that assistance from those judgeships, and it would be really a crucial injury if those judgeships lapsed and were not continued. But barring that authorization, I think that we will be back here year after year with a list of temporary judgeships that are very, very important to continue, asking the appropriators to extend those temporary judgeships as you've done, and as, again, we really thank you very, very seriously for.
Well, it's an issue we're going to have to continue to work on, but I think this committee hopefully will continue to support those judgeships, and unfortunately it creates uncertainty in our courts when we don't know whether those positions will continue every year, and so far this committee's done their work, but and we'll hopefully continue to do so, but certainly I think we all want to find a long-term solution. In terms of your judicial caseloads and the burdens that some of our judges are working through, what's optimal in terms of caseloads? How many do we have? Is it higher than optimal, I'm guessing, in many cases? What's the typical caseload for a judge? And how many more judges would we need? What would they cost? And I guess, what are the ramifications that we see in the court system by not having enough judges to cover the caseloads that are available?
Well, I'll start, and I have a feeling Judge Bates may well want to add something on this too. It varies greatly by district and part of the country how high a caseload individual judges carry. And we use a weighted case system in order to determine judgeship needs too, similar to the one I discussed with Representative Quigley for the defenders. And we have worked in the past on ways of alleviating this unbalance. We have an inter-circuit assignment process. There's a lot that's done within circuits to try to relieve this imbalance. We do have a judgeship bill pending, which Judge Bates may want to address. We'll probably supplement this answer because what I'm about to say draws on some very old knowledge on my part. So it's rough, it's from memory. When, back in the 1990s, I chaired the committee that is responsible for assessing judgeship needs, and the formula that's used for judgeships starts at about, if you have a caseload per district of around 450 per judge, that's the point at which you start looking at whether another judge is needed, taking into account other factors like the availability of senior judge help and some other things. For appellate judges, my memory is that subject to being corrected later, is that it's around 500 cases per panel. And there's a biennial survey. We have an elaborate process for determining judgeship needs.
I'll only supplement that very slightly. There is a very elaborate and careful process for determining judgeship needs, and each year the Judicial Conference for each Congress makes an assessment and a recommendation of any new judgeships. One way to describe the figures that Judge Gibbons just gave, which are, I think, approximately correct, is that the Judicial Conference standard, to pull this back into the temporary judgeships arena, the standard for considering whether to recommend a temporary judgeship be converted to a permanent judgeship is weighted filings per authorized judgeships that would rise above 430 if that temporary position was lost. And that's on the district court level. In terms of costs, I don't know the figures. I've heard some throw-around figures when you combine staff as well as the judge and the build-out for chambers of something around $1 million for a judgeship. But I don't know that that's right. We would have to supplement to give you a more accurate answer to that.
Thank you very much. We got time maybe for a couple more questions if other members have. Let me ask you a couple of questions about security, both court security and then courthouse security. I think this year you asked for an additional $33 million for court security. How do you go about making sure that's the most cost-effective, most efficient way to use money? I mean, tell me a little bit about how you decide what you need in terms of court security.
The security account is one in which it's pretty hard to control the cost, but we're committed to our obligation to do so. And we want to make sure, though, that we don't create security vulnerabilities when we cut costs. As you know, we're in a situation within the security account where part of the funds that are appropriated to the judiciary go to the United States Marshal Service that's responsible for providing our courthouse security. And then we also pay the Federal Protective Service to provide some additional security. This creates a little bit of I wouldn't call it a problem, but just a situation for us on both sides of that. We've worked, though, very successfully with the marshals to maintain oversight of our funds. Recent initiatives have been new CSO contracts that save some dollars through bidding. We went to fewer part-time CSOs while still retaining the flexibility that goes with the part-timers. We were able to eliminate some costs that recur through numbers like uniforms, medical evaluations, and such. We've eliminated 68 court security officer positions in overstaffed courts. We have some ongoing concerns about FPS. It creates a situation that's a little similar to our relationship with GSA, and we've not been as successful in getting our bills from the FPS validated. We were able to, we took a 30% cut in security and equipment during sequestration, and the CSOs had to work fewer hours. Those have been restored. But going forward, we have a real need for both new equipment that's just required on a recurring basis to keep up to date, and we have some deferred needs, time for cyclical replacements. That's just an overall problem. The $33 million, $32 million you referred to, actually, our spending is actually up, will actually be up if the full amount requested in the account were approved. Spending would be actually up $18 million, and that's based on an assumption that there will be no carry forward into 2015. We, of course, hope that that assumption proves not to be correct, and we will be updating you as we always do in May and September, and we hope to have some carry forward that will reduce the amount that's being sought from you.
Yeah, I think you did that last year. Let me, on the other side, on the court security, I know a couple of years ago we gave the GSA $20 million to say maybe you can go out and take a courthouse that rather than build a brand new one, that you could renovate it and bring it up to security standards. How's that worked out? Is that money all gone?
That's been done largely through the Capital Security Project that Judge Bates referred to previously, and he can elaborate on that further, but that's exactly what that was intended for and has been used for.
And very successfully, and we are grateful to the committee for its support of the program and hope that it will be reinstated for 2015 since it was not included in 2014. Those capital security program projects have been very successful. It's a way to spend a little less to address security needs only, where there really aren't space needs that go along with the security needs that would warrant new courthouse construction. There are many projects, including the one in San Juan that I referred to earlier, that are underway with fiscal year 2012 and 13 funds. We didn't get 14 funds. Hopefully we'll get 15 funds, and that's included in the President's budget submission, $20 million. We've got several projects ready to go that have been approved already by the Circuit Judicial Councils in Columbus, Georgia, Monroe, Louisiana, and Texarkana, Texas and Arkansas. And they're all in the $5 to $7 million range, and they address security concerns in the space, some of which are Marshals space concerns for prisoner security and the like. And it's important that it be recognized that it includes both judiciary and Marshals concerns and security needs, because without the capital security project, we can't really address the Marshals end of it, because with our appropriation money, we couldn't do anything with their space.
Thank you. Mr. Serrano.
Thank you. And I just told the world that GSA was looking at the possibility of building a courthouse in Puerto Rico, and
They'll be happy.
You just shot yourself down in 2 seconds. Offender supervision technologies. We always kind of leave that to the side because we seem to know about, ankle bracelets and all that. But can you discuss how probation officers use technology to improve the supervision of offenders?
There's really been a transformation of the way supervision is carried out as a result of all the technological advancements. You referred to electronic monitoring. We now use new technologies for drug detection, abuse of prescription drugs detection. Probation officers are able to use data mining computer services to better keep up with offenders. We have a PAC system, which is an internal system. I won't try to tell you what that stands for, in which officers are able to record their own notes and case events. We have an electronic data warehouse for probation and pretrial services officers to record workload activity, release data. We have another program called LENS that enables us to give electronic notice to local law enforcement if an offender is moving into an area. Offenders can report electronically, either online or at kiosk. And of course, all the probation and pretrial services officers have all these devices that they can use in the field or in the office. The same ones that all the rest of us use, the phones, the iPads. And one really interesting thing about this is how much the extent to which this revolution in technology of supervision goes hand in hand with our space reduction efforts, because one of the reasons you're able to reduce space for probation and pretrial services offices is because what technology has done for supervision.
Right. Mr. Chairman, I have one last question. I'm not a lawyer, but I'm told that a lawyer never asks a question that he or she doesn't know an answer to. But the answer will be, so I'll take a chance that I'm wrong on this one. How has the economy affected the reentry initiatives to help people come back and find jobs?
Well, as I'm sure you can imagine, it has had an impact. It's always not the easiest thing to place offenders in gainful employment, and of course the economy makes that harder. Another problem has been the lack of availability during sequestration of Second Chance Act funding, and that was, as you may recall, the funding that enabled probation officers to undertake so many of these initiatives that helped reintegrate offenders into the community, things like transitional housing, job training, educational training, cognitive behavior therapy, all those kinds of things. For 2014, courts can use their decentralized funds if they have them available for second chance funding. But for 2015, we've requested $2.9 million in dedicated second chance funding, and that will help very much with the reintegration of offenders in good times and bad.
Right. Thank you. As you know, Mr. Chairman, I'm not a lawyer, but I did play a judge on Law and Order once. And
Yeah, we know that.
and I told the DA to behave, and he didn't, so I threw out the case momentarily. But then they got it back.
Boy, good thing this guy doesn't have a law degree. Mr. Yoder.
You're just angry because you didn't get the part.
Wow, is right. Okay, a little bit of a follow-up on our last conversation regarding the amount of caseloads per judge. I think you said the optimal was 450, and that's when it means it's time to request a new judge or to look to, there's a need for a new judge at least. I don't know that I ever got an answer. What is the average caseload?
I don't have that figure. I mean, I'll have to,
Okay.
we would have to do some, we'd have to answer that supplementally. 450 for a district judge is the figure that I recall as being the figure at which you start looking for need. But to look at typical caseload across the country or average, we would have to give you that figure. It differs so much. And the raw figures that we would give you would not be the weighted figures that are much more meaningful in terms of evaluating what the workload of a court is. Also, the average figures wouldn't give you the caseload mix between
So how many
criminal and
judges are over 450 caseload?
I don't know. You would have to do that in the supplemental answer.
Okay. Judge, do you have any information
I don't
on that?
know that specifically. The only figures I have in my head or in front of me relate to those temporary judgeships. And those courts have pretty high average weighted caseloads, even including that temporary judge. It goes all the way up to over 1,200 in the Eastern District of Texas, and over 600 in Arizona, over 600 in Florida Southern. So some courts have very, very high
And
caseloads.
what's the
I
net
can't give you that.
what's the net effect on the public when our caseloads get to that amount per judge?
I think the primary effect on the public is delay. Delay
Judicial
in the
delays.
dispensation of justice.
Where do you see the highest demand for new cases right now? Where's the increase coming from, or where are the greatest demands on the court right now? What types of cases?
This is not a period in which the court's caseloads are rocketing up in any particular area. In fact, even the border courts, which of course have seen dramatic caseload since the very early 2000s, have seen a very modest diminishment lately, although we do not expect any dramatic decline. And of course, immigration reform could affect that greatly, probably on the upswing. But we do expect civil cases to increase somewhat. We expect criminal cases have declined a bit, and we think we may see that. Bankruptcy filings have been down somewhat, but we expect them to level off in 2015. Appeals court, I think those cases are pretty flat right now. So this is, you never know exactly what's going to happen next in the courts, and things that happen in the country generally very much affect that.
Well,
But this is kind of a stable period.
The economy was brought up earlier in terms of reentry programs. Those are things outside of your control that might affect the amount of folks that are coming back through the system, which will increase demand on the court system. You mentioned immigration, which is something that I don't know that Congress has really had much of a debate about regarding the impact on the court system. So I'm actually really glad you raised that as an issue, because that'll have to be taken into account. I think in previous years you mentioned when we passed significant reforms to enact, like redoing the bankruptcy code, or if we were to do tax reform or things like that, just kick up dust in terms of their new issues that have never been resolved because they're new laws that the courts will have to weigh in on, as there are portions of the laws that, for better or worse, this congressional process hasn't tied up every loose end, and the courts have to come in and weigh in. Are there things beyond immigration, or the economy was mentioned earlier? Are there other bills that are pending? The bill that relates to mandatory minimum sentences that's in the Senate, that Attorney General Holder is supporting the idea that we would eliminate mandatory minimum sentences, particularly for drug crimes. Does that affect the court system in terms of caseloads, or?
It does, but not in terms of caseload per se. The place where those kinds of sentencing reforms affect the judiciary is more in the release of people, but there's also some effects from caseload. If some of the sentencing reforms were put into place, it might mean some additional cases, because some of the reforms relate to changes in the sentences under the sentencing guidelines for certain drug offenses.
So they have to come back through.
So they would come back through the system, and that could be quite an additional workload for the courts. Early release programs have an effect, but it's on the courts more through the probation and pretrial services end of our resources than through new cases occurring.
Appreciate it. Thank you, Mr. Chairman.
Thank you. Mr. Quigley, and I would say if you're going to start your next round of questions with a joke, you might preface by the remark, here's another one you might not like.
Story of my life. I'm beginning to feel like Rodney Dangerfield. There's some humor in all of this, because it's better to laugh than cry about some of it, I guess. But following up on Mr. Yoder's questions about judicial productivity, and I preface it by saying some of my best friends are judges, but in watching them for 10 years, obviously some of them are more productive than others, much more productive than others. The difference at the federal level, it's not exactly like you can fire them if they're really unproductive. And I recognize that most are very conscientious and work hard, but how exactly do the courts handle this in trying to get judges to be more productive and move their caseload along faster and take more cases?
You know, it sort of depends on the situation. As you can imagine, this raises sensitive questions. I've been a chief judge of a district court, and if you're the chief judge of a court, whether a district court or an appellate court, you try as best you can to deal with the case of the unproductive colleague or the less productive colleague, and you try also to deal with what the underlying cause for that might be, if it's something other than simply just differing work styles. I mean, on the one hand, you do have to appreciate that judges have different ways of doing things, and they're entitled to make reasonable decisions about how to do things. On the other hand, if the productivity of a court as a whole is threatened, you've got some difficult decisions to make. You might have to figure out whether we can get the judge help, or whether there's something that you can do to encourage the judge to change his or her ways, and you hopefully do it in such a way that the judge won't simply resist it. If there's an underlying cause, then obviously that's another very delicate situation, and you have to try to address that. The courts really have tried as best they can to address all of those situations, and to do it with the best judgment it's possible to exercise in a given situation.
Let me add to that. Judge Gibbons has addressed it from the primary place that it needs to be addressed, which is locally, where the chief judge and the other members of a court can really grapple with any particular instance that may occur. But there are some national efforts to address it. We have committees of the Judicial Conference that do look at the productivity of courts, how far behind courts are in terms of the average time a civil case may take to get through the system, the time to get to trial, things of that sort. Our committee on case management and other administrative matters spends a lot of time looking at that and then reaching out to those courts and trying to give those courts additional help, guidance, expertise to try to make them more efficient. Congress has also done things that help. The Civil Justice Reform Act is basically a reporting system for district courts where judges wind up reporting cases where they have pending motions. Again, this is on the civil side, not the criminal side, which sort of has a timeline of its own that's statutory. But the civil cases, the Civil Justice Reform Act requires reporting of motions that are more than 6 months old, cases that are more than 3 years old, and those are mechanisms to prod judges to be more timely where there's a need to do so.
And I might say that appellate courts have internal reporting requirements so that the embarrassment factor figures there too.
I appreciate that. Thanks for your service. I yield back.
Well, thank you both, Judge Gibbons, Judge Bates, for your testimony this morning, and we look forward to working with you so that you can meet the constitutional needs that need to be met. And we appreciate the fact that you've been willing to work with us in these difficult economic times to try to do things more efficiently, more effectively, and that doesn't go unnoticed. So, again, thank you for being here today. The meeting stands adjourned.
We appreciate very much the opportunity to work with you all and the staff. Thank you.
Thank you all.
Having me approach this directly.
No, I would expect nothing less. I had a very fun relationship with most judges. Some of them didn't always appreciate it. I was emotional. I had 2 police officers testifying, and you exclude them so they're separate. And the second officer's testifying dramatically different. Like it was a whole different